Good afternoon and welcome. I'm Dana Locke, a business lawyer with Foley & Lardner. I'm pleased to welcome you to today's web conference on Rule 15c2-12, Preparing for February Changes, co-presented by Foley & Lardner and Marshfield Clinic Health System. Before we begin today's presentation, I would like to go over a few housekeeping items. Today's program will last approximately 60 minutes, followed by a question and answer session. We will respond to written questions at the end of the program, time permitting. Please type your questions into the Q&A widget that is open on the left-hand side of your screen. If you experience technical difficulties during the presentation, click on the question mark icon below the window. The presentation slides are available in the Resources section. This presentation is also being recorded and will be made available within the next few days. CLE credits are being offered for this program. We will be announcing the 5-digit codes at some point during the presentation. Those seeking Kansas, New York, and New Jersey CLE are also required to complete the attorney affirmation form. Enter the 5-digit code that will be announced during the presentation on the form and return the form to Brittany Morrow at Foley. Her email address is bnmorrow@foley.com. immediately after the program. To provide some additional background, I am of counsel and a business lawyer with Foley & Lardner, LLP, where I counsel governmental, healthcare, and cultural and exempt institutions in connection with financing transactions, including tax-exempt bonds, commercial loans, and on traditional financing products such as commercial paper, programs, and securitizations, and derivative transactions. With me today is Heidi Jeffrey, also from Foley & Lardner, and Larry Weimer from Marshfield Clinic Health System. Heidi is a partner with Foley & Lardner. She's a member of the firm's Finance and Financial Institutions Practice Group, Healthcare Finance and Restructuring, and Public Finance Service Practices. Heidi has experience in general municipal, private activity bond, housing, student loan, healthcare, and senior living finance. In such transactions, she has served as bond counsel and counsel to developers, underwriters, credit enhancers, issuers, and borrowers. Larry Weimer is the Treasurer and Chief Investment Officer at Marshfield Clinic. He has direct responsibility for oversight and optimization of the system's cash and investments, as well as debt obligations. Larry is a seasoned finance and operations leader with a variety of public accounting, not-for-profit, healthcare, and private industry senior management experience. He has expertise in financial management, financial reporting, treasury, debt, investment, strategic planning, structured finance, due diligence, process improvement, and business development. And now we will turn to the main portion of our program. Our presentation agenda includes a general discussion of the rule, incurrence of financial obligation, which is a definition you'll find in the rule, as well as materiality, reflecting financial difficulties, how the market is reacting, and how to prepare. That said, I'm going to turn this over to Heidi Jeffrey for a general discussion of the rule changes.
Thanks, Dana, for that introduction, and welcome everybody. We're excited about today's webinar, and hopefully everybody has February the 27th circled on your calendar. So these rule changes have been out for quite some time now, and before we get into the program, we want to walk through those rule changes. So as most of you know, in August of 2018, the SEC issued a release adding 2 new events to the rule, and the new events were added to the list of events that must be included in the continuing disclosure undertakings of both issuers or obligors of municipal bonds. And as noted before, February the 27th should be prominently circled on each of your calendars. Specifically, the amendments added 2 new events to the list included in the rule. So an obligor or an issuer must provide notice now regarding the incurrence of a financial obligation, if material, or the incurrence of an agreement which adds covenants, events of defaults, remedies, priority rights, or other similar terms of a financial obligation, any of which may affect a security holder, again, if material. And the second event that was added is to provide notice regarding a default event of acceleration, termination event, modification of terms, or other similar events under the terms of the financial obligation, any of which reflect financial difficulties. So obviously there's a lot of terms, a lot of language in both of those new events. So let's unpack them a bit. As noted again, and I keep focusing on February the 27th. February the 27th is the compliance date. So those continuing disclosure agreements that are signed on or after February the 27th must contain these two new rules. However, and this is just an interesting wrinkle, an event under the terms of a financial obligation, so I'll take a direct placement as an example. So an event under the terms of one of your continuing covenant agreements that occurs on or after February the 27th must be disclosed regardless of whether that obligation was incurred before or after the compliance date. So again, all of this brings into question an obligor and issuer's readiness to comply with these amendments after that continuing disclosure agreement has been entered into. As we begin to unpack, one of the things that really becomes critical is what is a financial obligation? How is it defined? How is it qualified by materiality? So let's go ahead and unpack these rule changes. And Dana, with that, if you want to take us through the concept of financial obligation.
So we have a definition of financial obligation, but there's some room for interpretation and, in particular, scope. The thought behind the rule was to address the lack of publicly available information regarding direct placements and other financial obligations. The FCC has amended the rule, as Heidi noted, to require timely disclosure of financial obligations of the obligated person if material, and any agreement that includes covenants, events of default, remedies, priority rights, or similar terms of a financial obligation of the obligated person, any of which may affect security holders if material. The scope of financial obligations that must be disclosed is broad. The clear focus of the release and the amendments to the rule is the provision of continuing disclosure relating to direct placement. The scope of the amendments is broader than direct placement. Larry, from an operational perspective, can you add some real-world color to the types of agreements and arrangements that you would see within the health system?
Sure. Thank you, Dana. You know, it's obvious that when they wrote the rule, they were focused on direct placements as one example, but they made a point of mentioning that it is broader than just direct placements. And when I take a step back and start thinking about this, you know, any form of a lease arrangement, whether it's a capital lease or even what used to be known or formerly will be known as operating leases, we need to be thinking about that as it relates to materiality, and we'll be talking about materiality a little bit later. Things like swap agreements or ISDA agreements, letters of credit, you know, traditional lines of credit. So it really is, it behooves us as practitioners, if you will, to look at this in the broadest sense and then start applying the materiality filters and, if applicable, the financial difficulty filters that we're going to be talking about. But I don't think we should just try and pigeonhole this into, oh, we don't have direct placements, we don't need to worry about it. That would not be an appropriate response.
And the term financial obligation itself is defined to include debt obligations, as Larry mentioned, derivative agreements, guarantees, or guarantees of debt obligations and derivative instruments. Further, these terms are interpreted broadly in the release, A debt obligation is intended to include a lease, leases that operate as vehicles to borrow money or leases that are debt-like. And Larry, I think that brings up your statement relating to operating leases. While a guarantee is intended to capture a contingent financial obligation of the issuer or obligor to secure the obligations of a third party or the issuer or obligor itself. Thus, an extremely wide range of obligations, if material, will need to be disclosed by EMMA or to EMMA by issuers and obligors. Heidi, can you talk a bit about materiality?
Yeah,
Dana, can I just, sorry to jump in. The other thing to think about here is GAAP versus defined terms from the SEC, and a lot of these terms aren't defined through the SEC, so we should be thinking about these in terms of GAAP as potentially the default or starting point, and then digging deeper from there.
And Larry, I think that raises a great point. As I think through some of the hospital clients that I work with, they have all flavors of guarantees, whether it's guarantees of a subsidiary's debt, guarantees, related to leases. There are, lots of different flavors. I think you've hit the nail on the head, though, when, we talk about the scope. Just understanding the scope, how do we go about kind of creating that inventory? And I think it hit the nail on the head. An easy place to start, I would think, is to pull out your most recent audit, take a look at the notes, take a look at the supporting, detail to see the worksheets, to see what sort of arrangements your organization has out there. And then from there, revert back to these definitions. So are we talking about debt obligations, derivative instruments, guarantees? As noted, all of this isn't going to have to be posted on day one, but it's important after the compliance date to begin really an understanding of what your organization has outstanding, because once you have that continuing disclosure in place that brings these new rules into effect, then you need to be far more sensitive to these two new events. Larry and Dana hit on, one of the additional factors in this new rule. The concept of materiality flows throughout the first new event. And as we've all struggled with recently with the MCDC initiative, this concept of materiality is, really a tricky one. It's always challenging. It's always events-based. We've, I think, historically thought about materiality in a variety of different situations. The standard always has been the qualification ideally would limit the amount of disclosure to events where there is a quote-unquote substantial likelihood that a reasonable investor would consider such information important in making an investment decision. I mean, that's the kind of customary standard of materiality. But I think as we've seen as of, recently, there's been a twist on that typical and customary standard of materiality. And what I'm referring there, of course, is to the MCDC initiative. I think there continues to be a lack of clear guidance regarding what is material to an investor in the marketplace. And that previously has led to a pretty conservative view of materiality and what at least one market participant has termed hyper-disclosure. And so there's, I think at least in the MCDC initiative, there was very much and disclosure relating to that initiative and attempts to kind of clean up prior viewed deficiencies, that arguably did lead to some hyper-disclosure. So the lack of clear guidance, we have our basic definition of materiality, but very facts and circumstances oriented. Larry, I'm wondering, from a systems perspective, from an organizational perspective, through what lens do you typically look at materiality?
Yeah, as you mentioned, it's always challenging, and it is kind of facts and oftentimes circumstances related. It would be nice and it would be easy if we could say anything over this dollar amount or anything over this percentage of assets or percentage of revenue is material. And I think that's definitely one threshold that we look at. But even if something doesn't trip that threshold, does not necessarily mean it is not material. I think other factors we need to consider is what would the impact on our overall covenants be? So if an organization is very close to a financial covenant and the dollar amount in and of itself is not material, but it triggers a default of some sort under a covenant, well, I think by definition that would jump it into the material category. Or if there are cross defaults involved and it impacts numerous other documents, I think that plays into materiality. So unfortunately, it isn't as simple as a hard dollar amount or a hard percent.
I think the materiality in the context of leases has also been, will raise some questions as well. Hospitals, issuers have quite a bit of, there are all sorts of lease arrangements, leases for equipment, leases for space and MOBs. I think there perhaps the dollar amount becomes relevant. One of the things that we always, run into is when we start talking about dollar amount is we know the auditors use $1, they typically work with their clients and come up with a dollar amount that is viewed to be material, and for notes disclosure purposes, items over X dollar amount get disclosed. I guess the question is that the appropriate standard? It seems to me that is a standard, but again, as we talk about leases and things like that, coming up with a dollar amount as it relates to leases, I think will be a difficult but important challenge. Larry, your thoughts on leases?
I agree with what you said. I think it's important for an organization to do an inventory and make sure they understand all of the leases. And yes, a hard dollar amount could make it very easy, but that is only one factor. So the importance of understanding the details behind the leases, any potential covenants within the leases, has been heightened because of this new rule.
I think with a particular emphasis on cross defaults as well. You could have an agreement that would be smaller dollar amount, but then contain cross defaults that would have a much more severe effect.
I know we'll be getting to this later on in the presentation, but I guess all of this is, making me think that getting one's arms around kind of the totality of these arrangements sooner rather than later, especially if your organization is an active issuer, if you think you're going to be in the marketplace, in the near term, because we're talking about so many different arrangements potentially, and Dana, your point on cross defaults and covenants is very well taken. I think this whole concept around incurrence and materiality is really something that an organization is going to need to wrestle with sooner rather than later in light of these two new rules.
This is Larry jumping back in, and another thought to consider, materiality is one thing. We're going to talk a little bit more about financial difficulties, and both of those are open to subjectivity. So something to consider is, if there is no formal right or wrong answer necessarily, make sure you document your thought process and your conclusions so that there will be some support for whatever conclusion you reach if it were ever to be questioned.
That's a very good point, Larry.
Yeah, consistency, I think, and you're right, we'll get to this later in terms of preparation, but one of the themes that we focused on through this web program is a focus on the need to develop policies and procedures surrounding secondary market disclosure. And I think in this instance, as these new rules come into effect, having a procedure or having a consistent approach in terms of how you view materiality, I think will be very important. And again, Larry, I think your point's very, very well taken. This next slide, as we point out, determining which events are material could be very difficult. And if the SEC does not later concur with the analysis, the consequences can be severe. Again, looking at that in light of the MCDC initiative and the consequences to obligors and issuers, investment bankers, and then the remediation process and the subsequent disclosures, all of that was an interesting process. So I think the other consequence, if you will, is in terms of 15c2-12 and an underwriter's requirement to have comfort that the obligor and issuer will follow through with their continuing disclosure obligation. I think it'll be interesting to see what the reaction will be from the banking and underwriters, community in taking a look at what an obligor views as its obligations, relative to materiality and posting a financial obligation. So, again, consequences relating to the SEC could be severe, but I guess I'd also point out that the consequences related to the view that your investment bank and counsel may take during the diligence process, that also is a consequence that needs to be considered here. Moving on, the use of a materiality standard without further guidance to qualify the events that must be disclosed, it gives rise to the concern that issuers and obligors will be required to provide detailed summaries of its direct placements, leases, or swaps, or to post in full redacted copies of the underlying documentation in order to comply with the rule. On that point, once we have a continuing disclosure agreement in place and once one of these financial obligations is entered into, I think it'll be interesting to see what exactly it is posted. I think this could go one of a couple of ways. So it'll be interesting to note and watch and monitor what exactly the form of this notice takes. And again, the last point on that slide, underscoring what we've been talking about, is, and we have an extremely wide range of obligations, if they're deemed to be material, will need to be disclosed to EMMA by issuers and obligors. Dana, I'd like to shift now into the second new event that's been added. And one of the items, as we had noted when we were introducing the second event, is, these these events which reflect financial difficulties and noticing those up. So I'd like to turn that over to you now, please.
Thanks, Heidi. One of the themes of the release in relating to the second new event is the timing of the disclosure of financial difficulties under current law. It's often delayed because from a practical perspective and historically, that information was included in an annual filing or quarterly filing that lacked some detail. The amendment seeks to address those two issues, timing and detail. The second added event of the amendments would require an issuer or obligor to provide timely notice of any of the following events: default, events of acceleration, termination events, modification of terms, or other similar events under the terms of a financial obligation of the obligated person, any of which reflect financial difficulties. In the release, the SEC first notes that the qualifying trigger that any of the events must reflect financial difficulties should allow issuers and obligors to distinguish between events that do not reflect financial difficulties, such as minor covenant violations, say the failure to comply or provide notice of a change of address, something small like that, compared to the failure to replenish a debt service reserve fund or to satisfy important operational covenant. And the former is likely to be evidence that the issuer or obligor's ability to pay its obligations when due has been compromised, while the latter could indeed be indicative of financial distress. Like materiality, the qualifier reflecting financial difficulties has not been clearly defined, nor has the SEC provided much guidance on how the standard should be interpreted. Note also that this requirement will apply retroactively to a listed event relating to any of the issuers or obligors' financial obligations, not those solely entered into after the compliance date. And again, this just brings in the point that both Heidi and Larry made, the readiness and to comply with the amendments is paramount at this point, circling the date February 27th on your calendar. Larry, do you have any real-world color to add?
Yeah, but before that, Dana, if we could go back just a couple slides, I think it's slide number 20, and this is something that can easily be overlooked. The default or event of acceleration, and the fact that the rule comes into effect at just the default level, not even quote-unquote event of default level. Do you want to just comment or clarify on that so that doesn't get lost in the shuffle?
Yeah, Larry, I can jump in there. What you're pointing out is an excellent distinction between a lowercase d default and an uppercase E event of default. And what the SEC is basically saying is we want our obligors and issuers to notice up problems even before they've technically ripened into an event of default. So this focus on a lowercase d default is an important distinction because, again, the the theme of this second event, if you will, is notice early of potential, financial problems. So these technical defaults that haven't ripened into events of default, even those need to be noticed up under this second new event.
Thanks. I didn't mean to go backwards, but it just occurred to me as you were talking that that distinction hadn't been made. But,
well, and as you tease out rightly so, all of these different events, lowercase d default, that's important. Event of acceleration, termination event. Termination event is typically something which we see in swap and derivative arrangements. Termination events can arise for a variety of contracted arrangements. Again, the ones that we need to follow on are which reflect financial difficulties. For instance, termination events can take place because you have prepaid or not defeased, because you've refunded or retired a series of underlying bonds or related bonds, in which case you have a termination event related to your swap. That may or may not reflect a financial difficulty. It's a factor, but termination events, again, as we talk about derivatives being financial obligations, that's an important one to note. Modification of terms. We very frequently see forbearance arrangements. That now, if that forbearance arrangement is being entered into because there is a financial difficulty, that would need to be noticed up. So again, I think we could spend a lot of time developing scenarios that could give rise to this, need to notice up the second event. But again, really what's, I think, critical here are this concept of any of which reflect financial difficulties.
Right. So then when I think about it from a real-world application perspective, something like lines of credit, which I view as normal operating procedure. We have several of them. We renew them annually. Sometimes we draw on them. Sometimes we don't draw on them. Never really gave it a lot of thought as it relates to disclosure, but under this quote-unquote new world order, we have to take a step back and say, okay, have I incurred a financial obligation at the time that I renew an existing line of credit, or have I incurred the financial obligation at the time that I draw on a line of credit? And I don't know that there's really a clear answer, and I think each client will need to have a conversation with their counsel to see how it gets interpreted. And then once you answer that question, you have to say, okay, well, is it a material line of credit, a financial obligation? And we talked about materiality earlier, so that comes into play. And then lastly, if you have existing lines of credit and you're modifying them in some way, you have to take into consideration, okay, is it because of financial difficulties? So I draw on a line of credit because there's some short-term cash liquidity issue. How do you assess whether that is a financial difficulty or whether that's normal operating procedure? And that's where you get into that subjectivity again, and you look at the facts, you look at the circumstances, you have a conversation, you document what your thought process is, and you move on. But all those things from a traditional line of credit really hadn't needed to be thought through prior to these new rules.
Well, yeah, and to take it even further, as you're giving such great examples, modifications of loan agreements with issuers, those come into place for a variety of different reasons. Modifications to revolving credit facilities or lines of credit, we wrestle with those frequently. Sometimes it's a simple amendment because you want to extend the term, but other times you go in and you make perhaps conforming changes to covenants, conforming to other arrangements that you have with similar banks. Those likely don't reflect financial difficulties, but what happens if you're in a declining covenant situation and you are making some modification? Your approach or your reason for making the modification may be as simple as we're trying to make a conforming change. But how, again, is financial difficulty defined? If you're in a declining covenant situation, maybe you're nowhere near, a default level. But if you're kind of playing, let's say you have a 1.1 to 1 coverage, if you were making changes when you're at all remotely close to your covenants, could a holder then come back and say, hey, you should have told us about that modification, because anything you're doing in this challenged environment could be perceived as reflecting a financial difficulty. it's a very difficult standard, I think. And Larry, as you're pointing out, facts and circumstances, and I guess I'll make a plug for the lawyers here, but I do think that it's something that organizations and issuers and counsel will need to discuss pretty carefully. And Larry, to echo the point you made earlier, I think consistency in the approach, will be key here. So, Dana, I think we interrupted you right about, we'll fast forward back to slide 22, where we were talking about readiness. Moving on, I think market reaction. Is there anything further, Dana and Larry, before we hit market reaction?
I don't think so, Heidi. I think that was a really helpful conversation.
So, market reaction. Personally, I have not seen any issuers or obligors voluntarily opting into the amended rule. So, I don't have any examples yet of borrowers that have voluntarily decided to move forward with a rule. So I think we'll have, I anticipate a lot more market reaction to come after February 27th, including, I think, what will be some very important questions during the due diligence process when an underwriter, gets set to underwrite an issuer and is otherwise satisfying its responsibilities around Rule 15c2-12. Mentioning broker-dealers, I think it's too early to tell how they will respond during the due diligence process and what might come from, the in-house counsel at various investment firms. As I just mentioned, under the new amendments, broker-dealers will have a far greater scope of events that require disclosure, and therefore a far more complex due diligence process will be necessary, or at least a more complex process that we anticipate. This is especially true because the SEC has indicated that simply relying on a certification of a borrower or issuer without additional inquiry is not sufficient to discharge the broker-dealer's duty under the rule. So we anticipate that broker-dealers and their counsel will be reviewing a wide array of documentation in order to comply the rule. Likely will be asking more questions of those personnel that are charged with Rule 15c2-12 responsibility. How exactly are you going to respond to these new events? And those conversations will likely be happening as part of the due diligence process. So in terms of preparation, I know, again, it's going to be kind of system by system, organization by organization, issuer by issuer. But Larry, would love to hear, further from you in terms of how you're thinking about preparation and, how your organization is getting ready for February the 27th.
Yeah, thank you, Heidi. I think it was you that had mentioned earlier, when we're trying to get the entire universe of potential financial obligations that would now fall under this rule, a good place to start would be the audited financial statements and looking at leases and other commitments. But the message I take away from this new rule is that depending on where you are within an organization, you need to have a very good partnership with your accounting department, a good partnership with your legal department, a good partnership with your real estate department or your facilities department, and make sure you are on the pulse of when and where these financial obligations could be incurred so that you can comply with the deadline. That's probably the biggest takeaway that I have. Policies and procedures and making sure that you document all of your decisions, because there is subjectivity in materiality, subjectivity in financial difficulties. You want to document how you reached your conclusions so that you can support them down the road if needed. That would probably be the second big takeaway. If I jump to slide 28, I talked about the process and procedures that are addressed in that bullet point. I think it's important to note that the 10 days is the traditional 10-day deadline that most of us would be familiar with. Nothing's really changed there. It just added 2 things that need to be complied with within 10 days. So the clock is ticking as it typically always is. Materiality, we talked about, that's going to be difficult to making that determination, and that's why we need to document it. And then to start the inventory is that last bullet point, which we have talked about. So the hypothetical, Heidi, I think you were going to kind of walk us through this, and it'll help bring to life things that we have spoken of previously.
Yeah, and before we get there, I would like to go back, if you don't mind, to this whole concept of defaults and monitoring defaults. I think this all gets into the preparation that you were talking about. It's very difficult, I think, to monitor a default which is not yet an event of default. So within an organization, and for those of our clients that have secondary market procedures, we'll be talking to them about how exactly to build a better bridge to some of those departments that you were referencing, Larry. I think the difficulty, one of the challenges will be in identifying the listed defaults in each of these arrangements. And when you think about it, for a hospital that has, multitude of leases, how do you then monitor or develop a system for monitoring lowercase d defaults? And how does that then get filtered up to the parties that are responsible for your continuing disclosure reporting? So I think that's going to be a very difficult challenge, because you could have a person with reporting responsibility, a default in a lease of which, for some of these huge systems or regional systems, even heck, a standalone, it's difficult to really make sure that the lines of communication are flowing between those in, say, a real estate group and those with reporting responsibilities. And so the focus on reporting defaults and events reflecting financial difficulty, again, I think one of the things we're really focused on is, even if the rules don't apply to you in the short term, just understanding how an organization or issuer is going to respond is critically important, given the complexity and the multitude of arrangements. So, I emphasize, Larry, what you're saying about preparation. I think that it's, a key. I think preparation is going to be key here, just given the, very extensive application that these new changes can have. So in any case, I wanted to emphasize that as part of the preparation. The other point I'll hit is the development of secondary market procedures, again, some organizations have them, some don't. I think it will be very important, again, as these rules become, or as the listed events become more complex, to really have a policy or a procedure in place, written, unwritten, but something in place where, you have people or a department that are responsible and have a process in place for educating those departments on the new rules that are applicable, again, when and if the organization signs a new continuing disclosure agreement. I think prior SEC guidance has suggested that the development of policies and procedures coupled with education, one of the best tools for purposes of compliance. So I think in terms of preparation, and one of the things that should be added to this slide, in addition to dusting off an organization's policies and procedures, consider doing some education around this for complex issuers. I think it will be really important that those with responsibility for some of these financial obligations, be they derivatives, leases, or other instruments and agreements, it's important to make sure that, again, the lines of communication when one of these arrangements is signed up, that the people with reporting responsibilities, that they're in the loop. So again, how to prepare, I think education is also going to be key here.
Hey, and I'll just jump back in. I know we're probably running short on time, but as you were talking, the other thought that occurred to me, again, practically speaking, anybody who's working in an organization, if you're ever updating job descriptions or restructuring a department, consider having within the job description for various folks, compliance with regulations or something. Be very specific so that you see that as well as you're going through any orientation or training for new folks.
Excellent. I think it's probably time for hypotheticals, and again, as a reminder, we do have the question and answer feature, so to the extent participants have a question that the panel hasn't yet addressed, feel free to type in your question, and we will do our very best to respond. So a hypothetical. I work a lot in healthcare, so I will pick a random hospital system. So a regional hospital system causes bonds to be issued March 1st of 2019. So we're past our February 27th date. Bond issue closes March 14th, and at closing, the system signs a continuing disclosure agreement with the new and improved list of rules or list of events, signs that agreement up at closing. October 1st.
I'm sorry for interrupting you.
Go ahead,
but this could also, there are many entities out there, many borrowers who have master continuing disclosure agreements. So this could also be in the form of an amendment to an existing master continuing disclosure agreement. Then the question there is application, and would it apply then to all new issues that are covered by that master continuing disclosure agreement, or just issues going forward? And I think that's a decision a system or a borrower has to make.
That's a great distinction, and I should have focused on it. You're absolutely right. When it comes time to closing, some issuers have continuing disclosure certificates, which are, specific to the bond issue. And you're right, very right, Dana. A lot of organizations have master continuing disclosure agreements. So it's very likely that those will need to be amended at the time of closing as well. So thank you. So as we think through the hypothetical, so we've now closed the bond issue with a continuing disclosure agreement that's been amended, or perhaps with a continuing disclosure certificate. We roll forward in the year, the system is eager to issue more debt, so it enters into a direct purchase agreement with a bank, and at the same time decides to amend an existing letter of credit agreement with that same bank to make conforming changes. What notices are required? What events do we need to be thinking about?
So I can jump in and tell you from my perspective, I think this, as I said earlier, brings to life a lot of what we talked about. The first sentence there, we enter into the direct purchase with a bank, stopping right there, that is the incurrence of a financial obligation. So obviously we're subject then to this new guidance. And the question becomes, was it a material direct purchase transaction? And if so, then obviously there would be disclosure. We talked earlier what needs to be disclosed, a summary, a redacted version, and we'll see how the market response evolves, and that would be a conversation you have with your internal senior leadership and with your outside counsel to decide what makes sense. But clearly, just the entrance into a direct purchase agreement, if material, would require disclosure. Then if you unpack the sentence a little bit further, anytime we amend an existing letter of credit agreement to conform with a bank direct purchase, you start getting into, okay, was that amendment driven by financial difficulties? I think in this case, absent any further information, we would say no. We're just making an amendment to conform with something else that we were doing. So we wouldn't necessarily need to disclose that. You could take it one step further and say, well, were you entering in the direct purchase obligation because you had financial difficulties? And then that, it can go on and on and on. But at its simplest state, it is the incurrence of a financial obligation. If material, you should disclose. The fact that you made an amendment to the letter of credit agreement simply to conform to the new direct purchase, I would say would not require disclosure of those amendments. Did I get it right?
I think you probably got it right. The other aspect of this is, let's say you decide not to disclose the amendment, and you fast forward to the next deal, and you have an investment banking firm underwriter that are taking an approach consistent kind of with the legacy of MCDC that said, hey, you should have disclosed that. And now, as a result of your failure to disclose, we are going to require, a notice to be posted at the time of the new bond issue, as well as disclosure. It is the likely impact of this rule change that every single amendment to every single arrangement is going to be noticed up. I mean, are we creating another situation where hyper-disclosure, where over-disclosure is going to be the rule? Why would an obligor issue ever not disclose something?
So we're getting close on time, actually, and we've got a few questions that have come in. I think that if we could, does it make sense for this group to address the questions now, or do we want to keep plugging ahead?
No, the hypothetical, Dana, was there just to fuel discussion, and let's move to the questions if you wouldn't mind reading those.
Sure. So one of the questions we've received is about joint ventures, and the question is, what about joint ventures where the joint authority has issued debt, and each party to the venture is obliged on a pro rata basis to share the debt and or provide some level of credit backstop? Would one entity's financial difficulties require AMA disclosure by the joint venture entity with no non-financial difficulties? This is a good question. And I see this more at, it would be, to me, and Heidi, correct me if you have or Larry, if you have a different interpretation, but that the rule is really, this would be facts and circumstances, but we'd be looking at on the joint venture level as opposed to the underlying obligor. Heidi and Larry?
I think that's right. When we look at financial difficulty, when we look at the second event of financial difficulty, we're looking at the financial difficulty of the obligor to the extent, and I'm sorry, I'm reacting off the cuff here, but to the extent the party to the joint venture, so the investor's obligor, to the extent that obligor is not having financial difficulty, I think it would be fine. Now, if as a result of the terms of the JOA, the joint venture arrangement, there's going to be some sort of significant cash impact on the obligor, or if there's going to be some massive accounting impact as a result of the problems at the joint venture level, I think those are all factors to be considered in assessing whether or not this is a noticeable event. But just, a problem with one of your joint venture partners, that in and of itself I don't think should be a problem. But to the extent you've entered into an arrangement which is going to, as a result of your partner's issues, if that's going to create issues for you, either from an accounting standpoint or a contractual standpoint, then I think you need to consider whether that rises to the level of a noticed event.
I think that, Heidi, that just brings home the issue that we've been raising throughout, which is that this really is a facts and circumstance-driven analysis.
Absolutely. Absolutely. Other questions?
We have a couple of additional questions, but we only have a couple of minutes, actually. I think that one we should probably touch on quickly, and that's whether or not the rule keys off of the sale date for a bond issue or the issuance date. Heidi, do you want to take that?
I have a couple of thoughts. I think, well, first of all, off the cuff again, I believe it's the issue date, but I would also suggest that one take a good look at what has been promised in your official statement. So if you have a closing date of, February 27th or later and an earlier sale date, you need to take a look at what has been disclosed to the public. And so if you've already taken that step of telling your new investors that you're going to comply, I think the question's entirely moot. But so to me, it's the closing date, not the sale date that drives this.
I agree with that. And we are also seeing issuers, despite the fact that they are not modifying continuing disclosure agreements at this point, actually disclosing in the offering documents, they're putting out now the fact that this rule is going to be in effect and that they intend to amend their continuing disclosure agreement going forward, even though it doesn't relate to that series of bonds, which is prudent. So
and Dana, are you saying in that amendment that they will retroactively agree that the new rules, the new events apply to outstanding series, or is it only going to be for the benefit of those series issued after February 27th?
That it'll be for the benefit of the series issued after the 27th.
Got it. Dana,
so
I know.
I need to, yeah, I'm sorry, Heidi. I need to give the CLE code really quickly. Our 5-digit code is H26R4. If you're seeking CLE for this session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly for those seeking Kansas, New York, and New Jersey credit. In addition to the polling question, remember you will need to complete the attorney affirmation form and return it immediately after the program. A copy of the form can be found in the resource list widget. As a reminder, certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. That's my last housekeeping item.
For those who may have missed it, can you please repeat the code again?
Sure, it's H26R4. And any questions, please contact Brittany Morrow at Foley.
Well, on behalf of Larry, Dana, and myself, we'd like to thank you for participating in today's webinar. Foley is pleased to offer these webinars on a as-needed basis when new topics and current events occur. So we look forward to having you join us on a next webinar. Again, thanks on behalf of the three of us, and we look forward to having you participate in a future webinar.
Thanks, everyone.
Thank you. Bye-bye.